Exemption clauses may seek to exclude totally a liability or simply to limit it. The terms exemption clause and exclusion clause are often used interchangeably. In this lecture, we also refer to limitation clauses. They all describe clauses with the same aim, namely controlling aspects of liability. A party wishing to rely on an exemption clause must show that it was a term of the contract, meaning that it was properly incorporated into the contract and that, properly construed, it covers the loss or damage which has occurred. This is known as construction of the contractual clause. Even if they can show both these things, the clause may still be invalidated under the Unfair Contract Terms Act or the Consumer Rights Act. We will start by discussing the challenges present in incorporating exemption clauses into contracts. As you have seen, or you will see in your guide and textbook, express terms, in other words, those terms that are chosen by the parties, become part of a contract either through signature of a document or notification. Signed terms are always incorporated, even if harsh or when not read or not understood. A good illustration of this rule is the case of Lestrange versus Graucob from 1934. In this case, the buyer of an automatic slot machine signed and handed to the sellers an order form containing in ordinary print the essential terms of the contract. In smaller print, there were certain special terms. One of them was, any express or implied condition, statement, or warranty statute-wise not stated herein is hereby excluded. The sellers signed and handed to the buyer a printed order confirmation assenting to the terms of the order form. The machine was delivered by the sellers to the buyers, who paid to the sellers an installment of the price. It turns out that the machine did not work in a satisfactory manner, and the buyer brought an action against the sellers in the country courts, claiming damages for breach of an implied warranty that the machine was fit for purpose. The sellers pleaded that the contract expressly provided for the exclusion of all implied warranties. The buyer replied that at the time when it was signed, the order had not been read and the person knew nothing of its contents. The clause excluded warranties could not easily be read owing to the smallness of the print. Note that there was no evidence of any misrepresentation by the seller to the buyer as to the terms of the contract. The court held that they had signed the written contract and had not been induced to do so by misrepresentation. Therefore, they were bound by the terms of the contract, and it was wholly immaterial whether they read it or not and whether they knew of its contents. You might think that this is a harsh judgment, but it is one that induces a degree of certainty into deal-making. Signing a document is a definitive demonstration of assent, unless of course there is duress or misrepresentation. For example, in Curtis vs. Chemical Cleaning from 1951, the plaintiff took a white satin dress to the defendant's shop to be cleaned and she was given a paper headed receipt. She was asked by the shop assistant to sign it. The plaintiff inquired why her signature was required, and the assistant replied that, in effect, the defendants would not accept liability for certain specific risks, including the risk of damage to any of the beads or sequins which were on the dress. In fact, this contained a condition that the cleaners accepted no liability for any damage whatsoever. When the dress was returned to the plaintiff, it was found to be stained, and she was awarded damages by the county court judge. He held that the defendants had been guilty of negligence and were not protected by their exemption clause by reason of misrepresentation as to his character. On appeal by the defendants, the court held that the defendants could not rely on the exemption clause because their assistant, by an innocent misrepresentation, had created a false impression in the mind of the plaintiff as to the extent of the exemption clause, and that's how he induced her to sign the receipt. What happens if a document is not signed? According to case law, such as Chapleton vs. Barry from 1940, the document must be something that is recognizable as a contractual document to the reasonable person. Also, the person entering the contract must have had a reasonable notice of the term. This last part is quite important, as what constitutes reasonable notice will depend on the circumstances and, crucially, the nature of the terms in question. The standard rules on incorporation by notice can be found in cases such as Parker v. Southeastern Railway from 1877, Thompson v. London Midland Scotland Railway from 1930, Thornton v. Shoe Lane Parking from 71, and Ollie v. Marlborough Court Hotel from 1949. We will focus here only on those clauses containing particularly onerous terms. In addition to ordinary requirements on the provision of reasonable notice, special attention must be drawn to any unusual or onerous clauses. Lord Denning dealt with this in a couple of cases, Spelling and Bradshaw from 1956 and Thornton v. Shoe Lane in 1971, and this was picked up later in Interphoto Picture Library v. Stiletto from 1989. What Lord Denning did is that he created what has become known as the red hand rule to describe the level of notice one needs to incorporate successfully particularly onerous terms such as exclusion clauses. In Interphoto, the plaintiffs ran a photographic transparency lending library. Following a telephone inquiry by the defendants, the plaintiffs delivered to them 47 transparencies together with a delivery note containing 9 printed conditions. Condition 2 stipulated that all the transparencies had to be returned within 14 days of delivery, otherwise a holding fee of £5 a day and VAT would be charged for each transparency retained thereafter. The defendants, they hadn't used the plaintiff's services before and they did not read the terms and conditions. They returned the transparencies 4 weeks later, whereupon the plaintiffs invoiced the defendants £3,783.50. The defendants refused to pay and the plaintiffs brought an action to recover that sum. The judge gave a judgment in favor of the plaintiffs for the amount claimed. On the defendant's appeal, the court held that where clauses incorporated into a contract contained a particularly onerous or unusual condition, the party seeking to enforce that condition had to show that it had been brought fairly and reasonably to the attention of the other party, and that since the plaintiffs had done nothing to draw the defendant's attention to condition 2, the condition never became part of the contract. Or alternatively, the defendants were relieved from liability under the clause. This red hand rule operates sometimes when a contract term is so harsh or so wide and destructive of rights that in order to give sufficient notice, it would need to be printed in red ink across the front of a document with a red hand pointing to it, or something equally startling. However, even if a term is incorporated properly into a contract, this doesn't mean that it will be effective. For this to happen, the term will also need to apply to the issue at hand, which brings us to the issue of construction. A term in a contract will only have consequences to the extent that the clause covers the circumstances of the case. A key question in dealing with exclusion clauses, therefore, will be whether, once incorporated, the term is properly construed. In other words, is the clause appropriately worded to cover what has happened? If you were insured for theft and not accident, you will not be covered if your car is damaged in a collision. This is the sort of thing we're talking about. A key concept in English law is that ambiguous clauses will be interpreted contra proferentem. This means against the party trying to rely on them. Particularly used for exclusion and limitation clauses, but is nonetheless a rule of general application. The burden of proof will be on the person trying to rely on the clause. They will have to convince the court that the clause does in fact operate to limit their liability in the issue at hand. See Andrews v. Singer from 1934. A key illustration of the rule are attempts to exclude liability arising from negligence. The courts have ruled in numerous occasions that especially clear words must be used to exclude this type of liability. But if the contract term expressly mentions negligence, then effect must be given to it. The crucial issue is when there is no express reference, are the words used wide enough to cover negligence? In Canada Steamship Lines v. The King from 1952, the duty of a court in approaching the consideration of clauses which try to exempt one party to a contract from liability was summarized in the following way. If a clause contains language which expressly exempts someone from the consequences of their negligence, effect must be given to that provision. If there is no express reference to negligence, the court must consider whether the words used are wide enough in their ordinary meaning to cover negligence. If doubt arises at this point, it must be resolved against the person trying to take advantage of the clause. If the words used are wide enough for the above purposes, the court must then consider whether the head of damage may be based on some other ground different from negligence, and consider then whether it would be covered. A reference in a contractual document to the contract being subject to general conditions available on request is sufficient to incorporate into the contract the terms contained in the current edition of such conditions. See Smith v. South Wales from 1978. But if the clause covers more than one liability, it may be taken to refer to non-negligent liability only. In White v. John Warwick from 1953, the plaintiff hired a tradesman's cycle from the defendants. The defendants agreed to maintain the cycle in working order, and Clause 11 of the agreement provided that nothing in this agreement shall render the owners liable for any personal injuries. While the defendant was riding the bike, the saddle tilted forward and he was thrown off and injured. The court held that although Clause 11 exempted the defendants, even if they were negligent, from their liability in contract, which was more strict than their liability in tort, it did not exempt them from liability in negligence. This means that if there are two possible heads of liability on the part of the defendant, one for negligence, the other one on strict liability, an exemption clause will be construed so far as possible as exempting the defendant only from liability and not as relieving him from liability in negligence. Finally, remember that even when there is an exemption clause that has been properly incorporated, and even on its true construction, it covers the loss of damage which was occurred, there are still circumstances that may affect its validity before we consider the treatment of such clauses for unfair terms. For example, any contractual deal will fail if agreement to the terms has been a consequence of misrepresentation, defined as a false statement of fact that leads the other party to enter into the contract. The Unfair Contract Terms Act of 1977 followed a series of unsuccessful attempts by judges to develop common law principles which would control what were commonly regarded as unacceptable and harsh exclusion clauses. For a summary of the development of rules about these clauses, see Lord Dennick's judgment in George Michael v. Finney Lockseeds from 1983. Note that ACTA, as the Unfair Contract Terms Act is known, does not lay down in general terms on what is fair and unfair in contracts. The Act generally applies only to the exclusion or limitations of business liabilities that arise in the course of business. In summary, we could say that despite its title, ACTA is not about unfair terms in general. It is virtually only about unfair exclusion clauses and limitation clauses. It says that some terms of this type can never be used, but others are rendered ineffective unless they are reasonable. It follows from the above that ACTA does not in itself impose obligations on a party. It merely controls attempts to exclude or limit an obligation that would otherwise arise. The Act amends general common law rules on exclusion and limitation clauses in certain situations. And it can be helpful to think of ACTA and the common law as separate layers when testing to see whether or not a term is unfair. ACTA divides clauses into three categories: those which are automatically ineffective, those which are effective if reasonable, and those by ACTA. One common error is to think that the Act subjects all terms to a reasonableness test. It doesn't. Broadly, the effect of ACTA is to render void or subject to a reasonable test any clause which tries to exclude or limit liability on the following grounds. First, we have liability for the breach of an implied term on the quality of goods entitled to them. Secondly, we've got liability for negligence, contractual or arising in tort. And thirdly, we have liability for the breach of express terms. Let us now have a closer look at some of the key provisions of the Act. The scope of ACTA is limited in two important ways. Section 1 provides that it only applies to business liability, apart of course from Section 6 and 8. And Schedule 1 removes certain contracts from its scope, notably insurance contracts and contracts concerning interests in land. ACTA applies mainly to clauses seeking to exclude or limit liability for breach of contract. Remember that it is of significance now only in relation to business contracts, as the Consumer Rights Act takes care of provisions relating to consumer contracts. Section 12 of ACTA defines dealing as a consumer. This is seen as a relationship where one party deals in the course of business and the other does not. Although in most cases it will be obvious that someone is a consumer, in some cases the meaning of consumer needs to be explored. See for instance the cases R&B Customs Brokers vs. United Dominion Trust from 1998, Stevenson vs. Rogers from 1999. Liability for negligence arises where there is a breach of a term to take reasonable care. This could be express or implied. See, for example, Section 13 of the Supply of Goods and Services Act in 1982. Or where an obligation to take care is imposed without a contract, for example, through the law of tort. ACTA Section 2.1 provides that liability for personal injury resulting from negligence cannot be excluded at all by any contractual term. Section 2, subsection 2, provides that liability for other types of loss resulting from negligence can be excluded if the reasonableness requirement is satisfied. This is tested using ACTA Section 11 alongside case law. Often reference is made to the implied terms you have seen in different parts of the module, which are based on the Sale of Goods Act of 1979 and the Consumer Rights Act of 2000. These are implied into various contracts concerning goods. Clauses which try to exclude liability for breach of these terms are not affected at all in consumer contracts and are subject to the test of reasonableness, Section 11 in case law, in other types of contracts, namely the business ones. ACTA is somewhat confusing because it deals with these terms in two sections, Section 6 and 7. To clarify, Section 7 deals with issues about the quality and fitness of goods in sale and hire purchase contracts, while Section 7 deals with them in all other contracts under which possession or ownership of goods passes, mainly contracts of hire, and where goods and a service are provided together, for example in works and materials contracts. The provisions are identical in their effect. We also need to have a look at Section 3. Section 3 of ACTA is a general control of contract clauses. It has two parts, both of which apply to protect consumers or anyone dealing on another standard business. Section 3.2a provides that a clause which excludes or restricts liability for breach is only valid if reasonable. This overlaps with the provisions about implied terms and negligence liability in Section 2, 6 and 7 because these sections already subject such clauses to control, but it also applies where the term breached is an express term or some implied term not covered in the other sections of ACTA. Section 3.2b provides that a clause cannot be an excuse to render a performance different from that which was reasonably expected or to render no performance at all unless such a clause is reasonable. The Law Commission, see report number 69, in including this subsection, was to prevent defendants getting around the other sections by claiming that the clause does not restrict liability for breach because the effect of the clause is to leave a particular obligation out of the contract altogether, so that the question of breach does not even arise. Its potential is large because it makes reasonable expectations rather than contractual terms the yardstick of any liability. The meaning of reasonableness is something that requires our particular attention. Not all exclusion or limitation clauses are subjected to this test of reasonableness. A common mistaken assumption is made by the students that they have to do this every time. Instead, terms should only be tested when another section of ACTA tells you to do so. This reasonableness test is relevant and only relevant under sections 2.2, 3, 4, 6, 7, and 8. Reasonableness is defined in section 11, and in some cases, Schedule 2 may also give guidance. The definition of reasonableness contained in the Act is in fact quite vague, but it has been interpreted many times by the courts, so we're used now to turn to case law for assistance. If a term is found to be unreasonable, it will have no effect at all. It will be struck out of the contract, and the courts will not replace it with another exclusion clause which is more reasonable. The decision in Jill v. Horatio Mayer from 1992 appears to mean that the reasonableness of a term will be judged not just in relation to the claim being brought, but in relation to any claim to which the term could apply. See George Mitchell v. Finney Lock Seeds from 1983 for an illustration of the application of this test. The Consumer Rights Act came into force in October 2015. It consolidates and clarifies consumer rights. It does not affect business-to-business contracts for which the provisions of the Sale of Goods Act 1979, Supply of Goods and Services Act 1982, and the Unfair Contract Terms Act of 77 remain in force as explained in your study guides and textbooks. However, where the contract is made between a business, or called a trader, and a consumer, the law in relation to implied terms and exclusion clauses underwent fundamental changes to the prior legislation. In Part 2, the Act provides a general safety net to prevent unfair terms from taking effect in contracts with consumers. These reflect the Unfair Terms in Consumer Contracts Regulations prior provisions. Section 63 of Part 2 has a list of terms which may or must be regarded as unfair. This will need to be read in conjunction with Section 64, which contains a list of terms which cannot be assessed for fairness. In its treatment of what we call unfair terms, the Act moves closer to the European standards of fairness as opposed to the ACTA language of reasonableness. For example, the reasonableness test from ACTA is replaced by fairness, including for negligence, which makes it much more in line with the UTCCR. Certain key prohibitions, like the ACTA ban on attempts to exclude liability for death or personal injury, remain. Let us have a closer look at the provisions of the Act. It is worth noting at the outset that building on European Court of Justice jurisprudence, for example the case of Pannon from 2009, the Court can consider unfairness in proceedings of its own motion. General definitions are set out in Section 2 of Part 1. A trader is a person acting for purposes relating to the person's trade, business, craft, or profession. A consumer is an individual acting for purposes wholly or mainly outside the individual's trade, business, craft, or profession. A person is not necessarily a consumer. This means that a business is defined much more in line with the principles of the Unfair Terms in Consumer Contracts Regulations. So an incorporated business acting outside its normal course of business cannot fall within this, but would need to rely on the existing legislation under the Unfair Contract Terms Act. In other words, an incorporated business cannot be considered a consumer under the Consumer Rights Act. Rights arising from the Act make it easier to challenge hidden fees and charges. The key terms of a contract, including price, may be assessed for fairness unless they are both prominent and transparent. Terms which are not fair are not automatically binding on the consumer, but one may still rely on them if one chooses to do so. Some examples of terms that may be unfair under the Consumer Rights Act: fees and charges hidden in the small print, a term that tries to limit the consumer's legal rights, disproportionate default charges, or excessive early termination charges. Section 62(1) of the Consumer Rights Act provides that an unfair term in a consumer contract shall not be binding on the consumer, with a test of unfairness contained in Section 62(4). This states that a term is unfair if, contrary to the requirement of good faith, it causes a significant imbalance in the parties' rights and obligations under the contract to the detriment of the consumer. A term is unfair if, contrary to this requirement of good faith, it causes this imbalance, and it needs to be against the interests of the consumer. The fairness test, therefore, includes the following main elements: significant imbalance, detriment to the consumer, and good faith. It must, however, be emphasized that the overall requirement is a unitary one. The question is whether a term overall is unfair. The elements of the test are recognized as being capable of overlapping with each other in their application to any particular set of relevant facts. Significant imbalance is concerned with the parties' rights and obligations under the contract. The requirement is met if a term is so weighted in favor of a business that it tilts the rights and obligations under the contract significantly in its favor. for instance, by granting the trader undue discretion or imposing a burden to the disadvantage of the consumer. Examples of the types of terms where an unfair imbalance is likely to arise include those that have the effect of restricting or excluding the consumer's normal legal rights, for instance saying the consumer has no right to seek damages where a trader is at fault, constraining the consumer from seeking the legal remedies to which their rights give rise, for instance compelling the consumer to take a dispute to arbitration, and imposing on the consumer additional obligations or risks which are not envisaged by law or unreasonably go beyond anything needed to protect the legitimate interests of the trader, for instance, imposing excessive financial sanctions on the consumer for breaching the contract. The above examples come from Schedule 2 to the CRA, consisting of an indicative and illustrative list of terms that may be regarded as unfair. They will offer significant guidance as to the application of this unfairness test. The inclusion of a term on the list does not necessarily mean that any clause of that type will necessarily be unfair. It will depend on the context in which it is put forward. Neither is the list exhaustive, meaning that a clause of a type that does not appear in it may nevertheless be found to be unfair. The list contains some provisions that are familiar from the controls imposed in the Unfair Contract Terms Act, such as clauses allowing the seller or supplier to provide inadequate performance or a different product or service from that contracted for. Other provisions reflect the common law rules relating to exclusion clauses, such as the restriction of clauses which the consumer had no real opportunity of becoming acquainted with before contract. In general, the list is concerned with clauses that allow the seller or supplier to impose on the consumer, for example by allowing them to cancel the contract without notice, or giving the seller or supplier exclusive rights of interpretation, or requiring the consumer to pay disproportionately high compensation for a breach. It is important to remember that the term or notice that is unfair is not legally binding on consumers. This does not prevent them from relying on them if they wish to do so. The Act enables consumers to challenge wording if they consider it unfair and do not wish to be relied upon against them. What this means for students of contract law is that the unfair terms legislation now consists of a dual reading of the Unfair Contract Terms Act and the Consumer Rights Act, as opposed to what we had before, which was ACTA and the UTCCR. But the approach remains broadly consistent.